wondering about the Rental Housing Act, and let me do this. Who knows the Rental Housing Act out of their heads? I don't either. But Section 5 is your most important section. You can already see why it's important, because it says provisions pertaining to lease agreements. So it's all the stuff that needs to be in your lease. So most important one. With the Rental Housing Act as well, let me just get a show of hands. Who's doing residential? Only commercial? Okay, a couple of you. So with this obviously does not apply to what? Commercial properties. We see that because it's the Rental Housing Act. You don't stay in a commercial property. So it only relates to residential properties. So if you go and have a look at Section 5 specifically, and I'm going to run through a couple of points with you, just to show you where we do get all our information on. I actually love doing these compliance seminars because people always ask me, but where do you get your information from? So today I can show you exactly where everything's in the legislation. So with Section 5, let's have a look at that. Section 5.2, a landlord must, if requested thereto by a tenant, reduce the lease to writing. It doesn't say the lease agreement has to be in writing. It says if the tenant asks, then the lease needs to be reduced to writing. This is obviously going to change with the Rental Housing Amendment Bill. Then, a lease will be deemed to include terms enforceable in a competent court to the effect that, let's have a look at 3A. The landlord must furnish the tenant with a written receipt for all payments received by the landlord from the tenant. Simple as that. It doesn't say you need to invoice, the tenant needs to pay on the first, but you need to give them a written receipt for all payments in this regard. This is vital. And now I'm going to tell you a little bit of a story that always crops up. Deposits specifically. A tenant says he's paid a deposit 5 years ago to a landlord who is self-managing. The landlord's got no record of the payment. Now he wants to sell the property and somebody wants to take over the tenant, but there's no deposit because there's no receipt. And I can almost tell you in the majority of situations, if something like that happens, the benefit of the doubt goes to who? Because you're supposed to issue receipts. So please keep that in mind when you're busy purchasing property, when you're busy investing in new properties. Make certain that all the receipts are in order for the duration of the tenancy that is currently in the property. We can skip a little bit. Let's go to 3D, if you don't mind. The massive one. The big one that we get all our questions on. We probably get about 20 questions a day at TPN regarding this specifically. But the deposit contemplated in paragraph C must be invested by the landlord in an interest-bearing account with a financial institution. And the landlord must, subject to paragraph G, pay the tenant such interest at the rate applicable to such account, which may not be less than the rate applicable to a savings account with a financial institution. Simple as that. Is there another way of handling deposits? Only if you're an agent. Because it's possible to mark in your lease agreement that the interest will be paid to the Estate Agency Affairs Board. But that's the only other way of handling deposits. Even if your lease agreement says that there's no interest payable to the tenant, you still have to pay interest to the tenant. The Act says so. You can't go and write this out of your lease agreement. So interest-bearing account and then pay it over. There's another question that we get of, should we open different savings accounts for each and every single tenant? We get that quite a lot. It doesn't specifically say you have to, but obviously it's going to make your reporting quite a lot easier because the tenant, in terms of the Act, can ask statements of their deposit and what's currently happening with their deposit. So it is a little bit easier. A lot of agencies don't go and do this. They go and populate one bank account with all the deposits of the tenant. I can't tell you which is right or which is wrong. The Act doesn't say. But obviously for reporting purposes, it might be a little bit easier. Let's move over to E. The tenant and the landlord must jointly, before the tenant moves into dwelling, inspect the dwelling to ascertain the existence of any defects or damage therein, and here's the kicker, with a view to determine the landlord's responsibility for rectifying any defects or damage, or with a view to register such defects or damage. So this is quite a nice one, because we get this quite often, that the tenant says, we did an incoming inspection, you said all these things are wrong with the property, when are you going to fix it? So what I would do if I was you is go and mark on your incoming inspection reports which ones should be fixed and which ones are just registered. Nice way of doing it. Go and mark it on your incoming inspection reports. But you see here that you need to go and do it. Most important thing about inspections is go and do inspections. That's the most important thing. Because if you can't, or if you don't do your inspection, sitting with a massive issue, because you can't hold the tenant liable for any damage to the property, because you don't have proof of the damage. So vitally important, they always throw these things out of court. If there's no valid incoming inspection and there's no valid outgoing inspection. I had a situation now that we did have a discussion about previously. We recently changed our lease agreements regarding signature of the documents, because you can basically amend a contract on an email because it's considered an electronic signature if you go and do it that way. So I had an agent that was about to go on leave. What happened was they changed the outgoing inspection date with the tenant over email. She didn't tell anybody that this date has changed. Tenant vacated the property without an exit inspection actually happening. Because everything was on email, it was considered to be an amendment to the contract. So they couldn't hold the tenant liable because no exit inspection was done. Landlord actually held the agent liable. No mandate anymore, no commission, and damages to the property. Not a pretty situation. So, currently with the TPN lease agreement, what we've got is you can only amend the agreement by handwritten signature and by something called advanced electronic signature, which is quite a lot different than just normal electronic signature. You actually have to be registered to use something like that. So I would suggest something like this, specifically with incoming and outgoing inspections. Make absolutely certain about your dates, but it's important. Go and do them, please. Moving over to F. At the expiration of the lease, the landlord and tenant must arrange a joint inspection of the dwelling at a mutually convenient time to take place within a period of 3 days prior to such expiration. This is ridiculous, isn't it? Why? Because the tenant's still in the property. His things are still standing there. Perhaps he had a rough Friday night and kicked a hole in the drywall, but he just moved a couch against it. You don't know. So in instances like this, if you agree to a certain specific time that you will go and do in the inspection, just stick to that time period and you're covered in that regard. There are some agencies, what they will go and do is that they'll do an inspection 3 days before and on the day of the vacating. I don't have a problem with that either. It's sort of like duplicating information. So go and do it as soon as the tenant vacates. Important thing to know over here as well is your outgoing inspection of the previous tenant is not your incoming inspection of this tenant. It needs to be 2 different inspections, please. Let's have a look at G. On the expiration of the lease, the landlord must apply such deposit and interest towards the payment of all amounts which the tenant is liable under the said lease, including the reasonable cost of repair and damage. So we all know that. We go and use the deposit if the tenant's caused any damages to the property. Interesting thing over here is, have a look at the time period. Right at the bottom, it says 14 days after what? Restoration. Now, restoration is not defined in the Act, is it? So what is restoration? It's when things have been fixed, isn't it? There's a little bit of a kicker over here that I'm going to tell you about now. But it's 14 days after it's actually been fixed. And this is calendar days, correct. So 14 days you need to go and pay back the deposit. Obviously, if there's no damages to the damages to the premises, it's within 7 days. We can have a look at provision I on that. But I just want to focus quickly on provision H. Here it says, the relevant receipts which indicate the costs which the landlord incurred as contemplated in paragraph G must be available to the tenant for inspection as proof. So it's not just we make up an amount that the tenant is liable for. You actually need proof that it's going to cost this much. I've had agents go to the EAB for certain things like this because they didn't have requisite proof. The owner just said charge them 12,000 Rand. So please go and keep those proofs. Go and get quotes. It doesn't say here you need to get 3 quotes. It just says you need factual expenditure proof. That's the actual expenditure on the property. That's what it's going to cost. Let's move over to K. Should the tenant fail to respond to the landlord's request for an inspection, as contemplated in paragraph F, the landlord must, on expiration of the lease, inspect the dwelling within 7 days. So here's a nice protection method for the landlord as well. Because if the tenant doesn't pitch up or they don't give you a mutually convenient time, whatever it might be, you can go and inspect that within 7 days thereafter and just send through the report to the tenant. That's fine. They're going to have to prove that you were incorrect. So it's a nice little protection method for the landlord built into the legislation. We can actually go right over to O. The rest of the stuff just deals with the replacement of keys and lost keys and all those things. They're not necessarily important for today. O. Should the tenant vacate the dwelling before expiration of the lease without notice to the landlord? So this is when the tenant absconds from the premises, correct, without giving you notice. They don't send you the 20 business days notice in terms of CPA, whatever it might be. They just leave. The landlord will be able to hold them liable for all damages, holding over damages to the property, as well as that contractual breach. The lease agreement will terminate or end on the day that the landlord realizes that the tenant's absconded. So a nice little protection method, once again, built into legislation. There's a lot of agents and landlords that say, but the legislation is so against landlords. Don't forget that. Or the rights are so mixed up. Tenants have so many rights, landlord. Don't see it that way. Use the legislation to your advantage. Here's another little one. The one that I always get stuck on. P. Any cost in relation to the contract of lease shall only be payable by the tenant upon proof of factual expenditure. So let me ask this. How much are you charging your letters of demand out for? 250 Rand? 150 Rand? Are you charging the cost that it actually costs? Very nice, because that's what you're supposed to do. You can't go and charge something extra. Here's another little one for you. There's been a lot of discussion in the marketplace regarding this. Administration fees. Now, I'm not going to take questions here. I'm simply going to ask. Who charges what on residential? 500 Rand? I'm going to sound like an auctioneer. 800, 950. 350. Who charges higher than 1,000 Rand? Do you see what a big discrepancy there is currently with how much you charge on admin costs? Basically, all that you will have to prove at the end of the day is that that was the actual cost involved. We get a lot of guys that go and charge, let's call it the credit check fee at like $500, where it's actually only costing 58 Rand. I'm sorry we're so inexpensive, but that's what it's going to cost you. So that's the actual factor in the expenditure in this regard. But on administration fees, I've had things go to the Rental Housing Tribunal where they've said 800 Rand is fine, 900 Rand is fine. You just have to prove that you applied your mind to the actual lease agreement. Simple as that. We can skip over 6 completely, not necessarily important today. And then a very, very, very important provision, specifically on sectional title. 8. A copy of any house rules must be attached to the lease agreement. Now, does attachment mean left on the kitchen counter for the tenant to have a look at when he moves in? Does it say it needs to be signed? It's obviously better, but it doesn't say it needs to be signed. If it's signed or initialed, you at least know that it's part of the documentation pack, but it doesn't say, it just says it needs to be attached. I had a very nice situation with this. Sectional title property. Student moved in. He was about 20 years old. This was a very strange complex. Strange in the sense that they had specific conduct rules that said you cannot smoke anywhere on the premises. Inside, outside, whatever it might be, you can't. This thing passed deeds office muster. It's not like we have in the Constitution, section 16(1)(6) that says you have the constitutional right to smoke in a building. You don't, okay? But this passed everything. They had a unanimous resolution to pass something like this. And the reason for that was about 3 years ago, one of the tenants fell asleep with a cigarette and burned down a portion of the body corporate. So they just decided, listen here, no smoking. Simple as that. The agent knew about this, forgot to attach the conduct rules to the lease. Moved in the tenant, didn't mark it on the lease agreement itself. I don't necessarily know what happened, but the tenant and the chairperson of the body corporate had a little bit of a tiff. I think it was regarding noise and nuisance. The tenant realized, this is quite strange. I don't see anybody smoking. He asked around. He found out that you can't smoke anywhere in the property. He was actually a smoker, but nobody knew that at that time because he used to smoke in the property. So every single morning at 6 o'clock, when the chairperson was having their morning run, he would stand on his balcony and have a cigarette. Quite a vindictive guy. I should probably not say this, but he used to go and smoke in his tidy-whities as well, which was not necessarily made the situation better, but they couldn't hold him liable for anything. So it's vitally important. Go and attach those rules specifically to your lease. I've had a lot of situations that this has actually occurred.